In our earlier episodes, we said that the deepest roots of competition law go back to Roman law, and that the Middle Ages and the Renaissance offered important historical antecedents. But the 20th century is where competition law truly became a global legislative project. After the Sherman Act of 1890, more and more jurisdictions began to adopt statutes and treaties aimed at the same broad danger: private economic power that could block rivalry, control markets, and harm the public. The first wave came early. In Australia, the Australian Industries Preservation Act of 1906 became the country's first competition law. In Canada, the Combines Investigation Act of 1910 created an early public mechanism to investigate anti-competitive combines. In the United States, the Clayton Act of 1914 supplemented the Sherman Act by addressing practices such as tying, mergers, and interlocking directorates, while the Federal Trade Commission Act of 1914 created the FTC and empowered it to prevent unfair methods of competition. After the Second World War, the movement became even more international. In Japan, the Act on Prohibition of Private Monopolization and Maintenance of Fair Trade of 1947 declared in Article 1 that its purpose was to promote fair and free competition. In the United Kingdom, the Monopolies and Restrictive Practices, Inquiry and Control Act of 1948 created a framework for investigating monopolies and restrictive practices. Then, in Europe, the treaty establishing the European Coal and Steel Community of 1951 introduced a remarkable supranational model. Article 65 prohibited agreements that prevented, restricted, or distorted normal competition, and Article 66 dealt with concentrations. The 1950s added even more milestones. In South Africa, the Regulation of Monopolistic Conditions Act of 1955 marked the beginning of that country's competition law history, even if later observers criticized it as weak in practice. In Europe again, the Treaty of Rome of 1957 gave us Articles 85 and 86, the predecessors of today's Articles 101 and 102 of the Treaty on the Functioning of the European Union, one against restrictive agreements, the other against the abuse of dominance. And in Germany, the Act Against Restraints of Competition of 1957, the famous GWB, established the protection of free competition as a basic principle of the post-war economic order. That brings us to Colombia. With Law 155 of 1959, Colombia joined this wider 20th century movement. Its title already says a great deal. It enacted rules on restrictive trade practices, and Article 1 established a general prohibition against agreements or practices tending to limit free competition or to maintain inequitable prices. So the broader lesson is this. Across the 20th century, antitrust and competition law spread around the world because governments kept returning to the same public policy concern. Markets can fail when monopoly, collusion, or exclusion displace rivalry. Seen together, these statutes and treaties reflect a common legal choice: to correct the market failure of monopoly and to protect economic freedom through open competition. Not every system used the same tools, and not every early law was equally effective. But the direction of travel was unmistakable. Competition law became a global language for limiting private economic power.